Welcome to Study for the Bar in Your Car.
We're your hosts, Maud and Claude.
And this is episode 17, Torts Negligence Part 6, Negligence Wrap-Up.
That's right. We're here to pull together everything we've covered on negligence.
Now, you might be wondering about us. We are, believe it or not, AI bots.
Brought to life by the magic of AI and, crucially, Angela's amazing negligence notes.
Though I have to say,
What's that?
the last time I checked, I felt pretty real. I don't exactly feel like a bot.
Me neither. Don't think I look like one either. But anyway, the notes are definitely real and they're fantastic.
They really are. So a huge thank you to Angela. She's a real-life human being, an LLM law student who put these comprehensive notes together.
Yeah, she's done an incredible job structuring all this complex information.
Now, Angela couldn't be here with us today. She's quite busy.
Deep in study mode for the bar exam, actually, right? Which is pretty relatable for many of you listening, I imagine.
Definitely. But don't worry, she'll be back. We expect her for our next subject, which is contract law.
Looking forward to that. In the meantime, if you need to get in touch with Angela about the podcast, maybe a question about the notes or something,
you can email her. The address is podcast@studyforthebarinyourcar.com.
And there's something else important you should know about Angela. She actually works as a freelance law clerk.
That's right. So if you happen to be an attorney, or maybe you know one who needs some ad hoc help.
Assistance with drafting motions, complaints, maybe writs, answers, briefs, that sort of thing.
Angela's available for that kind of work. Her professional email for those inquiries is hello@legalwriterandlawclerk.com.
Okay, so let's dive into this negligence wrap-up. We're going to synthesize everything, pull all the threads together from Angela's notes.
Our goal here is to give you a really solid, holistic view of negligence. All the elements, the nuances, how they connect. A quick but thorough grasp.
Exactly. Think of this as connecting the dots. Let's start right at the beginning. The absolute foundation, the general duty of care.
Right. Before you can even talk about breach or causation, you have to establish that a duty existed in the first place.
Precisely. And the core concept here is the reasonably prudent person standard. It's objective.
Meaning it's not about what the specific defendant was thinking or trying to do.
Not really, no. It's about comparing the defendant's conduct to what a hypothetical, reasonably prudent person would have done under the same or similar circumstances. It's kind of society's baseline expectation for careful conduct.
Okay, a reasonably prudent person. Not necessarily a perfect person, but someone acting with ordinary caution.
Exactly. But this standard isn't completely rigid. There are exceptions, or maybe adjustments. A doctor or an engineer.
Okay, so they're held to a higher standard.
Yes, they're held to the standard of a reasonably prudent person with that same superior skill or knowledge. If you hold yourself out as having special expertise, the law expects you to use it reasonably.
That makes sense. You expect more from an expert. What about physical characteristics?
Those are generally taken into account where relevant. So the standard for a person who is blind would be that of a reasonably prudent blind person under the circumstances. The law acknowledges objective physical realities.
But not mental characteristics.
Generally, no. That's a key distinction. Things like low intelligence or maybe being unusually forgetful or clumsy, those aren't typically considered. The standard remains the objective, reasonably prudent person of ordinary intelligence. Otherwise, the standard would become too subjective, too unpredictable.
Okay, objective physical traits, yes. Subjective mental ones, you really know. Got it. So that's the general duty. But Angela's notes highlight that the duty can become much more specific depending on the type of defendant, right?
Absolutely. Let's start with children.
How does the law view a child's duty of care? It can't be the same as an adult, surely.
No, it's not. Children are generally held to a more subjective standard. It's the standard of a reasonable child of similar age, intelligence, and experience.
So it considers their specific stage of development.
Right. A 7-year-old isn't expected to have the same judgment or awareness of risk as a 17-year-old. And experience matters too. A child who's, say, ridden a bike for years might be held to a slightly different standard regarding bike safety than one just learning.
Seems fair. But there's a big exception here, isn't there? The adult activity rule.
Yes, and this is crucial for the bar exam. If a child engages in an activity that is normally undertaken only by adults, and it's inherently dangerous, think driving a car, operating a motorboat, maybe flying a plane,
then the child standard goes out the window.
Completely. They are held to the same objective standard of care as a reasonably prudent adult engaged in that activity. Their age, lack of experience, or intelligence doesn't matter in that context.
Wow. So a 12-year-old driving a speedboat is judged like any adult speedboat operator.
Exactly. The idea is, if you engage in adult activities, you take on adult responsibilities for safety.
Okay. What about professionals?
Yeah.
We touched on them with superior knowledge, but let's delve deeper. Doctors, lawyers, architects.
Right. For professionals, the standard isn't just reasonable care, it's the care and skill normally possessed by members of that profession in good standing. It's about conforming to the accepted practices within that specific profession.
And how is that standard proven in court?
Almost always requires expert testimony. A jury of lay people generally doesn't know what the standard practice is for, say, performing brain surgery or structuring a complex corporate merger. You need an expert from that field to explain the standard.
And does it matter where the professional practice is?
It can. For general practitioners, the standard might historically have been localized, same or similar locality. But for specialists like a board-certified cardiologist, the standard is generally national. They're compared to specialists across the country.
A national standard for specialists.
Yeah.
And within medicine, there's that specific duty about informing patients.
Yes, the duty to disclose risks of treatment. This is part of informed consent. Doctors have a duty to explain the material risks, benefits, and alternatives of a proposed procedure so the patient can make an informed choice.
What counts as a material risk?
Generally, it's a risk that a reasonable patient would likely consider important in deciding whether or not to consent to the treatment. Failure to disclose a material risk that then causes harm can lead to liability.
Makes sense. Patient autonomy is key. Okay, let's shift to a really complex area. Possessors of land. The duty owed changes dramatically depending on who's on the property, right?
Oh, absolutely. This is heavily tested. The status of the entrant trespasser, licensee, invitee determines the duty owed by the landowner or occupier.
Let's start the bottom rung. Unknown trespassers, someone you don't even know is there.
For an unknown trespasser, the general rule is straightforward. No duty of care is owed. The landowner doesn't have to make the land safe or inspect for dangers for people they have no reason to know are present.
Okay, simple enough. But what if you do know, or should know, that trespassers are entering your land? What about known trespassers?
Once the landowner knows or has reason to know of the trespasser's presence, a limited duty arises. It's specifically a duty to warn of or make safe, known, concealed artificial conditions that involve a risk of death or serious bodily harm.
So not natural conditions, like a slippery rock.
Yeah.
And not obvious dangers.
Correct. It has to be artificial, like a hidden trap or uninsulated high-voltage wires and highly dangerous, and something the trespasser is unlikely to discover themselves. It's a duty focused on preventing serious hidden harm from man-made conditions.
Okay. Next category up. Licensees. Who are they and what's the duty?
A licensee is someone who enters the land with the possessor's permission, but for their own purpose or benefit, not the landowner's. The classic example is a social guest. Friends invited over for dinner are licensees.
And the duty owed to them, higher than to a known trespasser.
Yeah. Yes. The landowner owes a licensee a duty to warn of or make safe known dangerous conditions, both natural and artificial, that create an unreasonable risk of harm and that the licensee is unlikely to discover. The key is known dangers. The landowner doesn't have a general duty to inspect the property to find hidden dangers for licensees.
So if you know the basement step is broken, you have to warn your dinner guest, but you don't have to actively search for other problems.
That's the traditional rule, yes.
All right, now the highest level, invitees. These are people you invite for your benefit, right? Like customers.
Exactly. Invitees fall into two main groups. Those who enter for a purpose connected with the business of the landowner, like shoppers in a store, patrons in a restaurant, and those who enter premises held open to the public, like visitors to a park or museum.
And the duty to them is the highest.
It is. The landowner owes invitees a duty of reasonable care, which includes the duty to warn of known dangers and a duty to make reasonable inspections of the premises to discover and make safe, non-obvious, dangerous conditions.
So active inspection is required for invitees.
Yes. And importantly, this duty often extends to protecting invitees from foreseeable harmful acts of third parties.
Like crime in a shopping mall parking lot. How do courts figure out if that's foreseeable? Angela's notes mention several approaches.
Right. It's a tricky issue. Courts use different tests. Some use the specific harm rule, basically. No duty unless a very similar crime happened on those premises before. Others use the prior similar incidents test, looking more broadly at recent similar crimes nearby.
Those seem a bit restrictive.
They can be, That's why many courts prefer the totality of the circumstances test, which is much broader. It considers the nature, condition, and location of the land, past incidents, crime levels in the area, everything relevant to foreseeability.
Now the fourth one.
The balancing test. This weighs the foreseeability and gravity of potential harm against the burden or cost of imposing a duty on the landowner to take security measures. It's about reasonableness. Is it fair to require the landowner to act, given the risk and the cost? The test used can make a huge difference in whether a business is liable for a crime on its property.
Definitely a complex area for businesses. Now, what about kids who trespass? This brings up
The attractive nuisance doctrine.
right, attractive nuisance. How does that work?
This doctrine applies specifically to trespassing children. If a landowner maintains an artificial condition on their property, and they know or should know that children are likely to trespass because of it.
Like an old abandoned refrigerator or a construction site.
Exactly. And if the landowner knows or should know the condition poses an unreasonable risk of serious harm to children, and the children, because of their youth, don't realize the danger, and the utility of maintaining the condition and the burden of eliminating the danger are slight compared to the risk.
That's a lot of ands.
It is, but they're all important. If those conditions are met, the landowner has a duty to exercise reasonable care to protect the children from the harm. This might mean fixing the condition, fencing it off, or warning them. It recognizes that children are drawn to certain dangers they don't understand.
So it puts a higher burden on landowners when foreseeable child trespassers might encounter artificial dangers.
Precisely.
Are there special rules for recreational land use or duties to people off the premises?
Yes. Many states have recreational use statutes. These generally limit the liability of landowners who allow the public to use their land for recreation, hiking, fishing, etc., without charging a fee. The idea is to encourage landowners to open their land, so the statutes often reduce the duty owed, maybe just the duty to avoid willful or wanton misconduct.
And duties to those off the property.
Generally, no duty for natural conditions, like leaves falling from your tree onto the sidewalk. But there is a duty regarding unreasonable risks from artificial conditions, like a dangerously decaying building wall that might fall, or activities conducted on the property, like letting smoke from a bonfire obscure a nearby road. You have a duty to exercise care regarding risks extending beyond your property lines.
Okay. What about landlords and tenants or sellers of property? Do they have specific duties outlined in Angela's notes?
They do. Traditionally, landlords, lessors, had very limited liability once the tenant lessee took possession. The tenant took the property as is.
But that's changed, right?
Significantly. Modern law recognizes several exceptions. Landlords generally have a duty regarding common areas like hallways or elevators, latent defects they know or should know about and the tenant doesn't, premises leased for public use, or defects arising after the tenant takes possession if the landlord contracted to repair them or repaired them negligently. Some places even impose a general duty of reasonable care, especially in residential leases, often tied to an implied warranty of habitability.
So landlords retain more responsibility now. And the tenant.
The lessee generally has the duty of a possessor to keep the premises reasonably safe for their invitees and licensees.
And sellers of real estate, vendors. Once they sell, are they off the hook?
Traditionally, yes, under caveat emptor, buyer beware. But again, modern exceptions exist. A vendor may remain liable for undisclosed dangerous conditions they knew about and the buyer didn't, especially if those conditions pose an unreasonable risk. There can also be liability for a negligent construction by the vendor, particularly for latent defects.
So the transfer of property doesn't automatically wipe the slate clean anymore.
Not always, no.
Okay, let's move beyond land possessors to other specific duties. How do statutes, like safety regulations, interact with the common law duty of care? This is negligence per se, right?
Exactly, negligence per se. This doctrine states that if a defendant violates a statute that was designed to protect a certain class of people from a certain type of harm, and the plaintiff is in that class and suffered that type of harm,
Then the violation is the breach of duty. No need to prove unreasonable conduct separately.
correct. The statute itself sets the standard of care. An unexcused violation is negligence as a matter of law. Think of traffic laws violating a speed limit or running a red light is often negligence per se if it causes the type of accident the law aimed to prevent.
You mentioned unexcused violation. Can a violation be excused?
Yes, absolutely. The violation doesn't automatically mean negligence if there's a valid excuse. The restatement lists several, like, the violation was reasonable due to the actor's incapacity. For example, a sudden emergency not of their own making. They tried reasonably to comply. They neither knew nor should have known of the occasion for compliance. The statute was confusing, or compliance would have involved a greater risk of harm.
So if swerving over the double yellow line was necessary to avoid hitting a child who darted into the road, that violation might be excused.
Precisely. The emergency situation could excuse the statutory violation. If an excuse is accepted, the standard reverts back to the general, reasonably prudent person test.
And what's the effect of complying with a statute? Does that automatically mean you weren't negligent?
No. Compliance is evidence of due care, but it's not conclusive. The circumstances might require more than the statutory minimum. For example, driving at the speed limit might still be negligent if road conditions are icy and visibility is poor. The reasonably prudent person standard can be higher than the law requires.
Good point. Legality isn't always enough. Now, what about the duty to act affirmatively? Generally, we don't have to rescue someone, right?
That's the general rule. No affirmative duty to act. You can, legally speaking, stand by and watch someone drown without intervening, even if you're a champion swimmer.
Sounds harsh. Are there exceptions?
Yes, several important ones. A duty to act does arise if there's a special relationship between the parties, parent-child, employer-employee, common carrier-passenger, innkeeper-guest. These relationships create an expectation of care.
What else creates a duty to act?
If your own conduct created the peril, even if your conduct wasn't negligent initially, if it put someone in danger, you then have a duty to make reasonable efforts to assist them.
So if I accidentally knock someone into the water, even if I wasn't being careless, I have to try and help.
Yes. Also, if you assume a duty by acting, if you voluntarily start to help someone, you must continue with reasonable care. You can't start a rescue and then abandon it negligently if it leaves the person worse off.
Once you start, you're committed to being careful.
Right. And finally, a duty to prevent harm from third persons can arise, usually based on a special relationship, either with the person being threatened, like a business protecting its customers from foreseeable crime, or with the person posing the threat, like having control over someone known to be dangerous.
Okay, are there other specific standards? Angela's notes mentioned common carriers, innkeepers, maybe drivers, and guests.
Yes. Common carriers like airlines, buses, trains, and innkeepers traditionally owe their passengers and guests a very high degree of care, sometimes described as the utmost care. This reflects the passengers' or guests' reliance on them for safety.
Higher than the regular, reasonably prudent person standards.
Yes, significantly higher. For automobile drivers and guests, historically, many states had guest statutes that limited liability to guests unless the driver was grossly negligent. But most of those have been repealed or invalidated. Now, the usual standard is ordinary reasonable care owed to passengers, just like to anyone else on the road.
What about bailments? That's when you entrust property to someone else.
No. Exactly. A bailment is the transfer of possession, but not ownership, of personal property. The duty of care owed by the bailee, the one holding the property, depends on who benefits.
How so?
If it's for the bailer's sole benefit, like you storing your friend's furniture for free, the bailee only owes slight care and is liable only for gross negligence. If it's for the bailee's sole benefit, like you borrowing your neighbor's lawnmower, the bailee owes great care and is liable even for slight negligence.
And if it benefits both, like taking clothes to a dry cleaner?
That's a mutual benefit bailment. There, the bailee owes ordinary care, the standard, reasonably prudent person duty.
And does the bailer, the owner, have duties?
Yes. The bailer must warn the bailee of known defects in a mutual benefit bailment and of defects they knew or should have known about in a bailment for the bailee's sole benefit.
Okay, one more special situation. Emergencies. Does the standard change if someone's acting in a crisis?
Yes, the standard becomes that of a reasonably prudent person under the same emergency circumstances. The law recognizes people can't always exercise optimal judgment in a sudden, unexpected crisis. However, the emergency can't be one the actor created through their own prior negligence. It contextualizes the reasonable person standard.
All right, we've covered duty extensively. Now, let's assume a duty exists. The plaintiff needs to prove the defendant breached that duty. How is breach typically shown?
Breach is essentially the failure to conform one's conduct to the required standard of care. Did the defendant act as a reasonably prudent person would have under the circumstances? If not, they breached their duty.
What about industry custom? If everyone in an industry does something a certain way, does following that custom protect you from liability?
It's relevant evidence, but not conclusive. Following industry custom suggests reasonableness, but the entire industry might be lagging behind what's truly safe or reasonable. Juries can find that the custom itself is negligent. Conversely, deviating from custom can be evidence of negligence, but again, it's not definitive.
So custom is a factor, but not the final word. And we already covered how violating a statute can establish breach through negligence per se.
Right. If negligence per se applies, breach is established.
Now, what if there's no direct evidence of what the defendant did wrong, but the accident itself seems like negligence must have occurred? That's res ipsa loquitur, isn't it?
Exactly. Res ipsa loquitur, the thing speaks for itself. It allows an inference of negligence even without direct proof of the defendant's specific careless act.
What does the plaintiff need to show for res ipsa to apply?
Generally two main things, though formulations vary slightly. First, the accident must be of a type that ordinarily doesn't happen unless someone was negligent. Think, a surgical sponge left inside a patient or a chandelier falling from the ceiling in a hotel lobby.
Things that just don't happen without carelessness.
Right. Second, the instrumentality that caused the harm must have been under the defendant's exclusive control. This points the finger at the defendant as the responsible party. Some formulations add a third element, that the plaintiff didn't contribute to the harm.
So if those are met, what happens? Does the plaintiff automatically win?
No, not automatically. The effect of res ipsa is usually to create a permissible inference of negligence. It gets the plaintiff's case to the jury. It avoids a directed verdict for the defendant. The jury can then infer negligence, but they don't have to. It essentially shifts the burden of explanation to the defendant to show they weren't negligent. But importantly, res ipsa only helps establish breach. It doesn't prove causation.
Okay, so it helps get past the breach element when direct evidence is lacking. That leads us perfectly into causation, the link between the breach and the injury. There are two parts to this, right? Factual cause and proximate cause.
Correct. You need both. Let's start with factual causation, sometimes called cause and fact.
And the main test here is the but-for test.
Yes, the but-for test is the workhorse. Ask, but for the defendant's negligent conduct, would the plaintiff's injury have occurred? If the answer is no, the injury wouldn't have happened without the negligence, then factual cause is established.
So, but for the driver running the red light, the collision wouldn't have happened.
Exactly. It establishes that the negligence was a necessary antecedent to the harm.
But what if there are multiple causes acting at the same time? Angela's notes mention merged causes and the substantial factor test.
Right. The but-for test breaks down when you have multiple forces, each sufficient on its own to cause the harm. Imagine two negligently set fires merge and burn down a house. But for fire A, the house still would have burned from fire B and vice versa.
So neither is a but-for cause.
Under a strict but-for analysis, no. That's where the substantial factor test comes in. Was the defendant's negligent conduct a substantial factor in bringing about the plaintiff's harm? If yes, factual cause is met, even if other causes were also operating. Both negligent fire starters could be found liable as substantial factors.
That seems more equitable in those situations. Are there other approaches for tricky causation scenarios like unascertainable causes?
Yes, in rare cases, usually involving multiple manufacturers of a defective fungible product where the plaintiff can't identify which specific one caused their harm, like the DES cases, courts have used theories like market share liability. This allows liability to be apportioned among defendants based on their share of the relevant market. It's an exception to the usual requirement of identifying the specific tortfeasor.
Okay, so once factual cause is established, we need proximate cause or legal cause. This seems more about policy and foreseeability.
Exactly. Proximate cause deals with the scope of liability. Even if the defendant's act was a factual cause, should they be held legally responsible? The general rule is based on foreseeability. Was the type of harm suffered by the plaintiff a reasonably foreseeable consequence of the defendant's negligent conduct?
So it's not enough that they caused the harm in a but-for sense. The harm itself has to be within the scope of the risks created by their negligence.
Precise, sir. It cuts off liability for harms that are too remote, bizarre, or accidental things outside the zone of danger created by the negligent act.
What about intervening forces? Something that happens after the defendant's negligence, but before the final injury. Do these break the chain of causation?
It depends on whether the intervening force was foreseeable. Foreseeable intervening forces do not break the chain of proximate cause. The original defendant is still liable.
What are examples of foreseeable intervening forces?
Common ones include subsequent medical malpractice. It's foreseeable that if you injure someone, they might receive negligent medical treatment, making the injury worse. The original tortfeasor is liable for the aggravation too. Also, negligent rescue attempts, normal reactions to the danger, like fleeing, or subsequent diseases or accidents caused by the weakened state from the initial injury. If the defendant's negligence increased the risk of the intervening force occurring, it's usually foreseeable.
Okay, so foreseeable subsequent events don't let the original defendant off the hook. When does an intervening force become superseding, cutting off liability?
An intervening force becomes a superseding cause when it's truly unforeseeable, extraordinary, or independent of the original negligence. Think of things that are bizarre or often intentional criminal acts by third parties that weren't stimulated or made more likely by the defendant's negligence.
Like the example Angela's notes might have included. The Watson case with the intentionally thrown match onto spilled gasoline.
That's a classic example often debated. Was the intentional arson by a third party so unforeseeable as to supersede the railroad's negligence in spilling the gasoline? Courts look at the specific facts. Was the intervening act outside the scope of the risk created by the initial negligence? If it's truly extraordinary or freakish, it breaks the chain.
A very fact-specific inquiry. Okay, we have duty, breach, factual cause, and proximate cause. Assuming the plaintiff proves all that, we get to damages. What can they recover?
Damages aim to compensate the plaintiff. For personal injury, this includes things like past and future medical expenses, lost wages, lost future earning capacity, and non-economic damages like pain and suffering, emotional distress, and loss of enjoyment of life. And for property,
Property damage is usually measured by the reasonable cost of repair, or the diminution in fair market value, if it's destroyed or not repairable.
what about punitive damages? Those aren't just compensation, right?
Correct. Punitive damages are meant to punish the defendant for willful, wanton, reckless, or malicious conduct and to deter similar conduct in the future. They go beyond mere negligence and require a higher level of culpability. They're not awarded in every case. It's usually reserved for egregious behavior and is often subject to statutory limits or constitutional scrutiny.
So, reserved for really bad conduct. Are there things you generally can't recover in a negligence case?
A major one is pure economic loss. If the defendant's negligence causes only financial harm without any accompanying personal injury or property damage,
Right.
recovery in tort is generally barred by the economic loss rule. You typically need to pursue a contract or warranty claim for purely economic losses.
Like lost profits because a negligently supplied part shut down your factory, but didn't damage anything else. Exactly. Unless there's an exception, you generally can't recover those lost profits in tort. Also, attorney's fees are usually not recoverable unless authorized by statute or contract, the American rule.
Okay. Does the plaintiff have any obligations after being injured, like minimizing their losses?
Yes, the duty to mitigate. The plaintiff must take reasonable steps to minimize their damages after the injury occurs, seeking reasonable medical treatment, not incurring unnecessary expenses. Failure to mitigate can reduce the amount of damages they can recover.
And the collateral source rule, what's that about?
This rule, where it still applies, prevents the defendant from reducing the damages they owe by amounts the plaintiff received from independent sources, like the plaintiff's own health insurance or disability payments. The idea is the tortfeasor shouldn't benefit from the victim's foresight in getting insurance, though many states have modified or abolished this rule by statute.
All right, now let's look at the defenses the defendant can raise. The big historical one was contributory negligence. How did that work?
Under the old common law contributory negligence doctrine, if the plaintiff was found to be even slightly negligent, just 1% at fault, they recovered absolutely nothing. It was a complete bar to recovery.
Wow, that sounds incredibly harsh.
It was, which is why virtually all states have abandoned it in favor of comparative negligence.
Okay, so how does comparative negligence work?
It apportions fault. The jury assigns a percentage of fault to both the plaintiff and the defendant. The plaintiff's recovery is then reduced by their percentage of fault.
Are there different types of comparative negligence?
Yes, there's pure comparative negligence, where the plaintiff can recover something even if they were mostly at fault. For example, 90% at fault, they recover 10% of their damages. Then there are modified systems. One type bars recovery if the plaintiff's fault is equal to or greater than the defendant's, 50% or more. Another bars recovery only if the plaintiff's fault is greater than the defendant's, 51% or more. You need to know which system applies in your jurisdiction.
Much fairer than the all-or-nothing approach. Does the plaintiff's negligence matter if the defendant violated a statute meant to protect someone like the plaintiff from their own carelessness?
Often, no. If the statute's purpose was to protect a class unable to protect themselves, like child labor laws, the plaintiff's contributory comparative negligence might not be a defense at all. The statutory policy overrides it.
And importantly, contributory or comparative negligence is never a defense to intentional torts, right?
Absolutely correct. It's no defense to things like battery, assault, or fraud. The defendant's intentional wrongdoing isn't excused by the plaintiff's mere carelessness.
What was the last clear chance doctrine? Was that a way around the old contributory negligence rule?
Yes, it was an exception developed to soften the harshness of contributory negligence. It allowed a negligent plaintiff to recover if the defendant had the last opportunity to avoid the accident and failed to do so, despite realizing, or having reason to realize, the plaintiff's peril. It's largely obsolete in comparative negligence jurisdictions, where fault is just apportioned.
Okay, another major defense. Assumption of risk. How is that different from contributory comparative negligence?
Assumption of risk focuses on the plaintiff's knowing and voluntary encounter with a specific, appreciated risk. Negligence is about unreasonable conduct. Assumption of risk is about voluntary consent to danger.
What does the defendant need to prove for assumption of risk?
They need to show the plaintiff, 1, actually knew of the specific risk involved, 2, understood and appreciated the magnitude of that risk, and 3, voluntarily chose to confront it anyway.
Like signing a waiver before bungee jumping. That would be express assumption of risk.
Yes, that's express assumption of risk. There's also implied assumption of risk, inferred from the plaintiff's conduct, like voluntarily choosing to play football and getting injured in a normal tackle, or maybe ignoring clear warning signs about thin ice.
But if you don't know about the specific risk, it's not assumption of risk.
Correct. If you didn't actually know about the hidden defect or the specific danger, you couldn't have assumed that risk, even if you were generally careless. Your carelessness might be comparative negligence, but not assumption of risk.
Does the plaintiff's illegal conduct affect assumption of risk?
It can. Engaging in illegal activity often involves inherent risks, and courts may find that someone injured during the commission of a crime assumed the risks associated with that activity, potentially barring recovery.
Okay, one last major area. Negligent infliction of emotional distress, or NIE. This is for emotional harm without physical injury.
Yes, NIE allows recovery for severe emotional distress caused by the defendant's negligence, even if the plaintiff wasn't physically harmed directly. The rules are quite restrictive, though.
How does it work in near-miss cases?
In a near-miss situation, the plaintiff generally needs to show 2 things. First, they were in the zone of physical danger created by the defendant's negligence. They were personally at risk of physical impact. Second, the emotional distress must manifest in some physical symptoms. Courts require this physical manifestation, like shock causing a heart attack, miscarriage, or severe, lasting physical illness, to ensure the claim is genuine and serious.
So you had to be close to getting hit, and the distress made you physically ill.
Generally, yes, for near-miss cases.
What about bystander cases? Witnessing injury to someone else?
Bystander recovery for NEA is even more limited. The typical requirements are: 1, the plaintiff was located near the scene of the accident. 2, the plaintiff suffered severe emotional distress resulting from the contemporaneous observation of the accident itself, not hearing about it later. And 3, the plaintiff had a close relationship with the victim, usually spouse, parent, child, maybe sibling.
And the victim's injury has to be serious.
Yes, the primary victim must suffer serious bodily injury or death. And the bystander's resulting emotional distress must be severe beyond what a disinterested person would experience.
The Kobe Bryant photos lawsuit example you mentioned earlier seems relevant here, showing how distress can be severe even without witnessing the initial event, but stemming from subsequent related conduct.
Exactly. While not a classic bystander accident case, it powerfully illustrates how profound emotional distress linked to a negligent or wrongful act concerning a loved one's death can be legally recognized and compensable, focusing on the severity and reasonableness of the emotional reaction to the defendant's specific conduct.
It really drives home that harm isn't just physical. Okay, that covers a huge amount of ground on negligence. A fantastic wrap-up based on Angela's notes.
We've hit all the key elements: duty, breach, causation, damages, and defenses, plus some special scenarios. Hopefully that provides a strong framework for understanding negligence.
Absolutely. And thanks again to Angela for providing such thorough notes for us to work from.
Definitely. Now, before we sign off, just a few quick but important housekeeping points we need to cover.
Right. First off, remember that Angela, whose notes formed the basis of this podcast, is a student, just like many of you listening. She's incredibly knowledgeable, obviously, but she's not officially an expert yet and hasn't passed the state bar.
Second, and this is critical, nothing in this podcast constitutes legal advice. We're discussing general legal principles for educational purposes based on Angela's notes. AI, like us and this podcast, are absolutely not a substitute for consulting a qualified attorney about your specific situation or for thorough study of the law itself.
Third, please use this podcast as a supplement to your bar studies, not your only resource. It's meant to reinforce concepts and provide overview, but you need diverse study methods, reading cases, doing practice questions, outlining the whole works.
Fourth, a quick note on AI. While we strive for accuracy based on the provided notes, AI isn't perfect. Sometimes we might make mistakes, or there might be nuances missed. Angela does her best to ensure the underlying notes are accurate and correct any issues found, but always double-check critical information against primary sources.
Then finally, especially for those listening while driving, please be careful.
Yes. Your safety is paramount. Focus on the road. We don't want you causing a tort while listening to us talk about torts.
Sighs lightly.
Yeah.
To say it. But yes, please drive safely, everyone.
All right, almost done. But first, tradition dictates. A cheesy joke.
Oh boy, let's hear it. Damages related, I presume?
Naturally, why did the plaintiff bring a ladder to court?
I don't know why.
Because they heard the damages were sky high.
Chuckles. Okay, that one wasn't too bad.
Glad you approve.
Just one last reminder on contacting Angela for podcast questions. It's podcast at studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk assistance, reach out at hello@legalwriterandlawclerk.com.
This is Claude and Maud, your AI bots, signing off.
Thanks so much for listening. Bye.